Hello everyone, this is the video of legal studies and the topic that we have been discussing from a last a few videos, that is criminal law. So in today's video I will discuss Indian Evidence Act 1872. This is very interesting thing, especially when we discuss about any offense. So, what are the major questions that first come in mind? Okay, let's check it out. What are those questions? Whenever you heard about any offense, then what are those questions? है ना? The first question that comes in mind, that is, what is the evidence given off, isn't it? So that is facts, issue of facts or relevant facts regarding any offense, isn't it? Secondly, that is how the evidence of such facts are given. The evidence of such facts is given either by way of oral evidence or documentary evidence, isn't it? Once you get answer of this question, then the third question comes, that is, on whom does the burden of proof lie? Burden of proof, that is of particular fact, or you can also say onus of proof. To prove whole case lies on the prosecution in charge. So normally it is prosecution who needs to prove the offense. Okay, and the last question that comes in mind, that is, what is the evaluation of the facts? The evaluation is proof or presumption of proof. The fact is either proved, disproved or not proved, or there may be presumption that proof of facts may presume, shall presume or conclusive proof. So basically these four questions are very significant while deciding or basically court proceeding of an offense. Fundamentally, these four questions are very important, especially when court proceeding is going on in respect of any offense. है ना? So here is the role of Indian Evidence Act, because Indian Evidence Act now come to the topic that discusses all these questions and gives guidelines how to find the answer regarding all these questions, है ना? So now let's check out the Indian Evidence Act 1872. The Indian Evidence Act, which contains a set of rules and allied issues governing admissibility of evidence in the Indian courts of law, originally passed in India by the Imperial Legislative Council in 1872 during the British period, है ना? So this is centuries old act. Keep in mind what it does. It contains a set of rules as mentioned here and allied issues governing admissibility of evidence in the Indian courts, है ना? So simple. So the next point is, it came into force on September 1st, 1872. And lastly, it is the masterpiece work of Sir James Fitzjames Stephen. Therefore, he could be called as the founding father of this comprehensive piece of legislation. Okay, so this is the brief introduction about the act, that is Indian Evidence Act. Now let's check out what exactly Indian Evidence Act is. The Indian Evidence Act is the rule book that defines about evidence and also describes how facts can be proved through evidence. Remember the four questions that we have discussed in the beginning? See, the same things it is defined here. Secondly, the act helps judiciary to separate the wheat from the chaff, which means it gives the idea to distinct between true and false, and that ultimately helps judge to decide the case. Further, Act not only explains what can be considered as evidence, but rather it also guides that what can be admitted as evidence, how it can be admitted, how the burden of proof has to be discharged, etc. Okay, so the Act also guide to use an appropriate and uniform rule of practice and prevent the inaccuracy in the admissibility of evidence. So see how important it is, isn't it? Because without evidence, no offense can be proved. Now, let's check out the principles of Indian Evidence Act. What are the major principles of Indian Evidence Act? The first one is, for any offense, help to find the most appropriate evidence where no scope of doubt. So this act basically helps to find the most appropriate evidence where no scope of doubt. So if there is any doubt, then there is a problem, you know the fact. Okay. The next principle is, the evidence must be relevant only to the issue that is in question. So if anything that is not relevant to the issue, then that won't be considered as evidence in a particular case. Okay. And the third and the last principle is, that is, the evidence gathered through hearsay is not a genuine or trustworthy evidence. Hence, it is not admissible in the court of law. What does it mean? That if someone heard that someone else was saying this, so that is known as hearsay, and that kind of information given in the court is not admissible. If someone himself or herself witnessed something, only then his or her statement will be considered admitted. But if he or she is saying something said by someone else, that is basically hearsay, wouldn't be accepted. Okay, so these three are the significant principles of Indian Evidence Act. Okay, now let's check out the classification of Indian Evidence Act. Okay, the Indian Evidence Act primarily classified into three parts, where it has total 11 chapters and 167 sections. Okay, part 1 has 2 chapters and explained from section 5 to 55. The first chapter is preliminary chapter, which introduces to the Evidence Act, and the second chapter specifically deals with the relevancy of the facts. Okay, now come to the second part, that is, it has 4 chapters covering from 3 to 6, as first 2 chapters covered by part 1. So from 3 to 6 covered by part 2, and we know that there are total 11 chapters. Okay, and explained from sections 56 to 100. Chapter 3 deals with facts which need not be proved. Chapter 4 deals with oral evidence. Chapter 5 deals with documentary evidence, and Chapter 6 deals with circumstances when documentary evidence has been given preference over the oral evidence. So it is clear now what what part 1 does and what part 2 does. Okay? And the last one is part 3. That is, this part has 5 chapters. The remaining 5 chapters, that is from 7 to 11, and explained from sections 101 to 167. Chapter 7 deals with the burden of proof. Chapter 8 talks about estoppel. Chapter 9 deals with witnesses. Chapter 10 talks about examination of witnesses. And the last chapter, that is chapter 11, deals with improper admission and rejection of evidence. Okay, so this is all about the Indian Evidence Act in brief. Okay, now there are certain terminologies that I would like to explain, and you should understand that, isn't it? With the purpose of general information or a specific information, doesn't matter, but you should understand this, namely confession and admission. The term confession appears for the first time in section 24 of the Indian Evidence Act. This section comes under the hearing of admission, so it is clear that the confessions are merely one species of admission. Okay? Confession is not defined in the Act. Pay attention. Justice Stephen, in his Digest of the Law of Evidence, states what? That is, confession is an admission made at any time by a person charged with a crime, stating or suggesting the inference that he committed that crime. So what does it mean? That there are a few points that you need to understand from this sentence. Basically, confession is not defined in the Act. Okay. However, it is discussed in section 24 of the Indian Evidence Act. The second point. The third point, as the person who drafted this Evidence Act, according to him, confession is such kind of thing that accused can accept, admit, or confess any point in time during the trial. Okay? So it is the acceptance of the act that an accused did. Okay? As all of us know that no accused or no person can be forced for the self-incrimination. Okay, and it is fundamental right, Article 20, remember. Okay, so further, section 17 to 31 deal with admission generally and include section 24 to 30, which deal with confession as distinguished from admission. So it is different from admission. Admission talking about the admissibility of the evidence in the court. Confession is normally or usually acceptance of the guilt or the criminal offense that is done by the person himself. Okay? It can be understood as if the conviction can be based on the statement alone. Please pay attention. It is confession, and where some supplementary evidence is needed to authorize a conviction, then it is an admission. So, what this sentence is saying, that simply, if any confession that needs additional support, evidence to prove that confession, then it is known as admission. For example, if I committed a crime and I am just confessing that I have done it, I have killed someone, but what is the proof? Why and how someone or court will trust me? that it is me only who killed that person. In that case, I need to give the evidence again based on my confession. I need to give the details about the murder weapon, about the crime spot, and everything of such kind which are related to the crime. And if that is verified, so in such a condition it is known as admission, not a confession. This is the basic difference. Now come to the next point, that is forms of confession. So what are the major forms of confession? The first one is judicial confession. Okay, a judicial confession has been defined as plea of guilty on arrangement made before a court if made freely by a person in a fit state of mind. See how beautifully explained this. So try to understand. Any confession that is done in front of the judge or magistrate or in the court, that is known as judicial confession. Simple. And what it is a plea of guilty on arrangement. Okay, means if you accept, confess your act, your offense, then possibly you will be given the lesser punishment than defined punishment of that particular crime. So this is the value or importance of the judicial confession. Okay, the second one is extrajudicial confession. So any confession that is not given in the court or in front of magistrate is known as extrajudicial. Simple. So the confession made elsewhere than before the magistrate or in court is known as extrajudicial confession. So an extrajudicial confession has been defined to mean a free and voluntary confession of guilt by a person accused of a crime in the course of conversation with persons other than judge or magistrate, seized of the charge against himself. For example, a man after the commission of a crime may write a letter to his relative or friend expressing his grief over the matter. This may amount to confession. Got the point? But here I would like to take your attention to note down a point, that is extrajudicial confession can be accepted and can be the basis of a conviction only, please pay attention, only if it passes the tests of credibility as laid down in the procedural laws. Okay, so it's not like that if someone claiming that I did it and that will be accepted, not at all. It must be verified, isn't it? So our last forms of confession is, that is other type of confession, basically conversation to oneself. Interesting, na? Yes, it is. Sometimes people talk to themselves. If that is recorded and proved by any other means, then it is accepted as evidence. For example, in Saho versus State of Uttar Pradesh, the accused who was charged with the murder of his daughter-in-law, with whom he was always quarreling, was seen on the day of the murder going out of the house, saying words to the effect, "I have finished her and with her the daily quarrels." Okay, the statement was held to be a confession relevant in evidence. It is not necessary for the relevancy of a confession that it should be communicated to some other person. So, What does it mean that if someone is talking himself or herself and it is somehow recorded and someone evidenced, something like that can be proved, only then it will be accepted, otherwise not. But this is one of the forms of confession, keep in mind. Okay, so this is all about the Indian Evidence Act, where we have discussed the introductory part of the Indian Evidence Act, that is when it is enacted, who drafted, what is the concept and meaning of Indian Evidence Act, what are the principles of Indian Evidence Act, classification of the act, and confession and admission. We have discussed all these points in detail. So now I believe you must have the idea that what Indian Evidence Act is all about, isn't it? So this is all for this video. See you in next video. In the meantime, you watch it again.